It's 11:30 on a Wednesday evening, and you're in a small conference room with your two lawyers. Everyone is exhausted, a bit on edge, and you're finding it a bit difficult to focus your mind. Your thoughts are racing. Have we considered all the important points? Am I accepting too little? Asking for too much? What are the tax implications? Am I doing the right thing for my family? Litigation is a difficult situation at best. At worst, it's like a mini war. If you want to learn about Florida probate and trust litigation, stay tuned. Today I'm here with Jonathan Burns. He's of counsel with the Duffy Law Firm, and he assists us on our probate and trust litigation. Welcome, Jonathan.
Thank you, Brian. It's great to be here.
We have going into the mediation, but of course we're open and flexible. If during the course of the mediation, like I just said, if we discover maybe a point of our case is a little bit not as strong as what we had hoped for, or the opponent's case is either a little stronger or a little weaker, that'll help us adjust. But it's better to have that discussion ahead of time and make an adjustment at the settlement than it is to go into the settlement thinking, well, sometime during the course of the day, I'm going to figure out exactly what my best position is.
Absolutely. And the mediator plays a huge role in this because he or she is going back and forth between the two parties. Oftentimes the mediator knows things that the other sides don't even know, and the mediator can help guide both sides to try to bring them together. The best types of mediators are not just those that are carrying numbers back and forth. They're making a connection with both the lawyers and the clients on both sides. And obviously the mediators are typically either retired judges or experienced attorneys, so that the credibility is there. So when the mediator says to a lawyer or to a client, hey, I think this is your best.
Or even a poor result. And how do you get a great mediator? Your litigators should have experience with the mediators in the community. And so we know the mediators. And Jonathan and I will often pick different mediators for different purposes. Like one mediator may be great for a little widow situation, and where we're representing the widow and she's the fiduciary, and there's some unhappy beneficiaries and they're complaining, and certain mediators' talent and skills and experience may fit well in that situation. Or in another situation, we may want a different mediator where we're representing a bank or a trust company, or we're representing some kind of a established fiduciary that maybe has a lot of experience in the area of wills and trusts, like another attorney. And we want somebody with more of a sort of a hard view of what the facts are and what the law is. So that's critically important. What you just said, choosing the right mediator, in order to have a successful, settlement opportunity is important.
Absolutely. And to that point, the personality of a mediator also comes into play. So if we have a particularly difficult client or lawyer on the other side, we might choose a specific mediator that matches up with that personality.
Exactly.
Or if we have someone that needs to not be pushed around, we need a little, more of a laid-back personality, we might pick that type of mediator. And having the experience in this area of the law, having mediated hundreds of cases, you get a pretty good feel for the type of mediator that you need. You can't just use one specific mediator in every single case.
Right. Now, you brought up another point a minute ago, which I wanted to sort of hit on again, which was you were talking about a monetary framework for a settlement, which, as we know, and probably even viewers without experience at home in our area in probate and trust litigation understand, usually when you're involved in these kinds of situations, sooner or later, there may be a number of different factors that are at play, but sooner or later it's going to probably boil down to a dollar amount is a likely common ground to sort of resolve the issue. Now we have a slide which we're going to show you where if you just consider, like, there's two sides of the slide. There's a purple side and a yellow side. On the purple side you see a $4 million number, and on the yellow side you see a $1 million number. Just hypothetical, but this is an example of a BATNA process that we may go through with a client, and this is sort of somewhat taken from a discussion we had with a client in a real life situation. So our client was, let's say, on the purple side, and what he wanted was anywhere from $3 to $4 million was basically a pretty good, in his mind, settlement number. 4 million was like, really excellent, and 3 million was pretty good, and 3.5 million would have been very good. 2.5 million was somewhat acceptable. So going into the settlement, these are the kind of things that he was thinking about. The other side, as you might imagine, was diametrically the opposite. They wanted it to be as low as possible. So they were hoping to get out of this with $1 million settlement, and if they had to go as high as $500,000, 1.5 to 2 million, that was a possibility, but they wouldn't have been happy with it. So that's just the beginning point, is the numbers, the dollars. There's a lot of other considerations. So, as you can see in this slide, one of the things that we're going to talk about in the settlement and the mediation is time is a factor. So let's say that the opposing side has come to us at the end of, or near the end of the mediation, and they've said they're willing to come up with $3 million. That's the number. And after that, they're going to walk, and we're going to go to court and all that stuff. When we go back to the client and we're talking about whether or not he or she should accept the $3 million, we got to think of some other factors and sort of layer them on top of that consideration. So time is one factor. I mean, if our client is absolutely convinced that we're going to win in court, they might have to consider the fact that it could get appealed, and it could be 2 years to get to an appellate review.
Absolutely, and it's time, value, money. During that time, what could our client be doing with that money? Are we being paid on a contingency or hourly basis, as we have cases in both situations? And what's the potential success at trial? Is 4 million the max that we could get at trial, or could we get more? If 4 million is the max and they're offering 3.5 million, and there could be an appeal, and we could charge a significant amount of time in order to get that 4 million, then these are different values and different factors that any client's going to have to consider, because with $4 million in investments and whatever they're going to do with that money, they might be able to make up that money, or a portion of that money, during those 2 or 3 years that it takes an appeal to go through.
Exactly. And we want to consider the fact that there's a risk when you go to court. We don't want to be afraid to go to court, and we don't want to be afraid to take that risk. For example, if our client, we felt we had a strong case, and we felt like there was a very good chance that we were going to prevail in court, and the other side was adamant that they weren't going to budge off of 1 million or 1.5 million, then we might say, it's worth the risk, because we really feel like when we get in front of the court and in front of the jury, we may get as high as 4 million or more, as you pointed out. So, time is a factor, risk is a factor. There's other factors too in costs. We talk about, if it's going to go to an appeal, there's going to be a lot of additional legal costs and fees and other costs that are not necessarily monetary costs, like emotional costs on the families and things like that. We also didn't really talk about, but one of the things we consider is form. Sometimes when you're in negotiation and everybody's focusing on the numbers, there might be, let's say we're at a number and we can't get either side to budge, but we really don't want our client to necessarily undergo the risk of the trial and the appeal and, the prolonging the ordeal. Maybe there's something we could do with form. For example, maybe we could accept some part of a partnership, which we've done in some cases, and the client felt like it was only a $2 million value on the partnership at this point in time, but within a few years, they believe that partnership could be worth, 20, 30, or 40% more than that. So the form of payment or the structure of the payment, weighed into this BATNA. The BATNA, the best alternative negotiated agreement, you can't overemphasize how important that is, and you should know about it, and you should work with the attorneys and your CPA and your investment advisors before you go into the settlement or before you go into trial, so that you got a good understanding on exactly what's going on.
Absolutely. Every form of compensation is on the table. We will prepare you, and like Brian said, whether it's an accountant, whether it's a financial advisor, whether it's a real estate broker, all of that information is relevant, and if it's going to bring the best resolution for our clients, then that's what we're going to bring to them at mediation or before.
So now we've gone through everything that we're going to talk about today. We talked about the pre-litigation phase, we talked about the discovery phase, we talked about the motions, and we talked about mediation and settlement. And the next phase would be actually going to trial. So we're going to do another video shortly where we'll focus on trial and talk pretty much about that. Remember, this is the Q&A section, so this is like the quick answers to probate and trust litigation. We're also going to do a video more in depth, probably in a couple parts, where we call client conversations. And on Duff Law Digital, client conversations are the more in-depth and more detailed discussions about whatever the subject is, whether it's a probate and trust litigation matter, whether it's an administration matter, estate planning, real estate, whatever it is. So we hope you enjoyed the video, and we hope you'll subscribe. Don't forget to hit the bell so you get notified. We're doing about 2 videos a month on Duff Law Digital on different subjects. So if you subscribe and hit the bell, you'll be sure to get notification, and you can follow us on Facebook, Instagram, LinkedIn, and Twitter. So look for more videos. And Jonathan, thanks very much for spending time with me today.
Thanks for having me.
All right. Stay tuned.